Today, let's talk about a case that's less like a dry legal proceeding and more like a high-stakes thriller. This is a story where the Supreme Court of India literally put itself on trial, faced its own major mistake, and, in doing so, actually strengthened the very idea of justice. Welcome to our explainer on the landmark case, A.R. Antulay versus R.S. Nayak.
Here's how we're going to break it all down. First, we'll look at the idea of a court correcting itself. Then, we'll get into the nitty-gritty of the huge error at the heart of this case. After that, we'll examine the legal principles that were basically put on trial. Then comes the climax, the landmark 1988 verdict. And finally, we'll explore why this case is still so incredibly important today.
All right, let's dive right in. The whole story here, the entire legal drama, it all boils down to one single massive question, one that really gets to the heart of judicial power itself.
I mean, really think about that for a second. We're taught to see the Supreme Court as the final word, right? The ultimate authority. But is it perfect? Is it infallible? Can its decisions ever be challenged, especially by itself?
And that yes was huge. It wasn't just a quiet admission. It was a powerful, clear statement from a 7-judge constitutional bench. They essentially said that the pursuit of true justice is more important than even the court's own finality. This case established that the court doesn't just have the power, but it has a solemn duty to fix its own mistakes.
So, what was this big mistake? What was the so-called crime that put the court's own reputation on the line? Well, it all goes back to a major jurisdictional blunder made in 1984. It was a decision that probably seemed like a good idea at the time, but it actually violated the very law it was supposed to follow.
So here's the backstory. A.R. Antulay was the chief minister of Maharashtra. Back in 1982, a man named R.S. Nayak filed a private corruption complaint against him. Now, the law was very clear. A case like this had to be heard by a special judge. But then, on February 16, 1984, the Supreme Court did something no one saw coming. It took the case away from the special judge and transferred it directly to the Bombay High Court.
And right here, you can see the problem in black and white. On one side, you have the law, Section 7, Subsection 1 of the Criminal Law Amendment Act of 1952, which says these cases must be tried exclusively by a special judge. No ambiguity. But on the other side, you have the Supreme Court's order, which just completely sidesteps that law.
And this is the core of the problem. The Supreme Court basically tried to give the High Court power that it didn't have. Only the legislature, through law, can decide which court hears which case. Now, this wasn't just some small procedural mix-up. It actually created a special, one-of-a-kind legal process just for Antulay, which is a big no-no. By doing that, the court trampled on his fundamental right to equality under Article 14 and his right to personal liberty under Article 21, which includes the right to a fair trial according to the law.
Okay, so the court made a massive error. How in the world does it go about fixing it? How do you reverse a decision from the highest court in the land? Well, the 1988 bench pulled out 2 powerful legal doctrines. Think of them as their investigative tools to take apart the old decision.
You know, for any law student, this is just fascinating stuff. A court can't just come out and say, "Oops, our bad." It has to legally prove its own mistake using established principles. It's like they had to build a legal case against themselves.
Their first tool was the Doctrine of Per Incuriam. It's a Latin term that literally means through lack of care. Basically, a decision is called per incuriam if the court that made it completely overlooked a critical law or a binding past decision. It's like having a huge judicial blind spot. So the 1988 bench looked at the 1984 order and said, yep, this is a classic case of per incuriam. Their reasoning was simple and sharp. The earlier court, in its effort to fast-track the trial, completely ignored the fact that the 1952 Act gave exclusive jurisdiction to the special court. They missed a crucial piece of the puzzle.
The second tool was another key Latin maxim, Actus Curiae Neminem Gravabit. It's a foundational principle that simply means an act of the court shall prejudice no one. It's all about basic fairness. You shouldn't be harmed because the court itself made a mistake.
The court argued that its 1984 mistake had clearly harmed Antulay. It put him through a trial process that the law didn't allow, violating his fundamental rights. So, because of this maxim, the court had an absolute duty to fix it, to basically hit the rewind button and put him back in the position he was in before the error was ever made. It's all about making things right.
So that brings us to the grand finale of this legal showdown, the verdict from the 7-judge bench. After carefully analyzing the error and using their legal tools, the court was ready to deliver its judgment and, with it, restore justice.
And that number says it all.
7. This wasn't some routine appeal. This was a full-blown constitutional bench, brought together for the specific purpose of dealing with a crisis the court itself had created. The weight of the entire judicial system was on their shoulders. Their ruling had to be more than just a correction. It had to be a powerful statement about the rule of law.
And their findings were crystal clear. The 1984 order, it was declared totally void, like it never even happened. The court stated, without a doubt, that the order violated Antulay's fundamental rights under Articles 14 and 21. And maybe most importantly, it firmly declared that the Supreme Court has both the power and the duty to fix its own errors. And so the case was sent right back to where it should have been all along, the special judge.
The court was also very clear about where it gets this power. It pointed to Article 142, which allows it to do complete justice. But, and this is a really important but, it clarified that this power can't be used to just ignore a law passed by Parliament. It also talked about its duty to correct errors ex debito justitiae as a matter of justice and its inherent power to step in whenever fundamental rights are on the line.
And this quote, wow, this really gets to the soul of the judgment. The court basically said, look, judges are human, we can get it wrong. But admitting a mistake and fixing it doesn't make the judiciary look weak. Actually, it does the opposite. It makes people trust the system even more because they know that, in the end, justice will be done.
So, why are we still talking about a case from 1988? Because its impact was massive. It set a precedent that is still shaping Indian law to this very day. The Antulay judgment created a vital self-correction mechanism inside the judiciary. Courts now have a clear path to fix their own mistakes. That doctrine of per incuriam we talked about, it's now a standard tool for lawyers to challenge bad judgments. And finally, the case acts as an important guideline for how the Supreme Court should use its incredible powers under Article 142.
If you take away just one thing from this whole case, let it be this. While having final decisions is important for law and order, it's not the most important thing. When a court's error violates someone's fundamental rights, the search for true justice has to win, every single time.
And that leaves us with one last thing to think about. The Antulay case suggests that humility is a strength for a court. But what do you think? When the highest court in the land admits it was wrong, does that make you trust the system more or less? It's a big question, and one that every single one of us, especially those of you studying law, should really consider.